In 40 years on this bench, I've had people threaten me with lawsuits, with phone calls to the mayor, even with their daddy's badge. But the morning a federal agent walked into my courtroom and pointed a gun at me, that was the day I understood that some people will do anything to stop justice. I still think about that Tuesday in February. Cold, gray morning. Providence in winter has a particular kind of silence to it, the kind that settles into your bones before the city wakes up and remembers it's alive. I'd gotten to the courthouse at 8:10. Old habit, same as always. My father, Giuseppe Caprio, used to lace his work boots before sunrise every single morning. Never complained, never asked for extra time, never showed up late to the construction site, even when his back was giving him trouble. He'd look at me over the kitchen table and say, "Frank, the day you stop showing up early is the day you stop caring." I've never forgotten that. 40 years on this bench, and I have never once been late to court. Christina had the coffee ready when I walked in. Strong, black, the Italian way, the kind that actually wakes up your conscience, not just your eyes. She was already at her desk sorting through the morning docket, her reading glasses perched on the end of her nose, lips pressed together the way she does when something in the paperwork bothers her. In 20 years working together, I've learned to read Christina the way a sailor reads weather. When she's relaxed, the morning will be routine. When her lips press like that, the morning will not be. "Judge," she said, setting a file on top of the stack before I even sat down. "This one's unusual." She'd said that to me exactly twice before in 2 decades. Once, when a sitting city councilman showed up drunk and tried to bribe me with an envelope of cash in open court. Once, when a mother brought her 3 children to testify against their own father. Both of those mornings had changed something in me permanently. I picked up the file Christina had flagged and read the name at the top. Special Agent Raymond Holt, Federal Bureau of Investigation, Field Office, Providence, Rhode Island. Now let me be clear about something. I have enormous respect for the FBI. The men and women who serve in federal law enforcement, who work long years building complex cases against organized crime, against corruption, against people who think their power puts them beyond accountability. They deserve our deepest respect. I've worked alongside federal prosecutors many times over the decades. Good people, serious people. People who understand that the law is not a tool for personal advancement, but a structure that protects every single citizen equally, from the wealthiest business owner in the city down to the woman who cleans his office at midnight for $11 an hour. But the file in my hands that Tuesday morning told a different story entirely. Agent Raymond Holt, 44 years old, 17 years with the Bureau, decorated, commendations from 3 different directors, on paper, an exemplary career. He was before my court on a straightforward matter, a contempt citation filed after he had directly interfered with testimony in a case I was handling 6 weeks earlier. The details of that interference I'll get to shortly. But what the file could not contain, was what was going to happen when Holt walked through my courtroom doors at 9:30 that morning. What no docket, no incident report, no supplemental filing could ever prepare you for. I set down the file and sipped Christina's coffee. I looked out through the narrow window behind my desk at the February sky, flat and white like old paper. I thought about my father, the way I always do when something heavy is coming. Giuseppe Caprio came to this country from a small village outside Naples, with nothing except a willingness to work and a deep, unshakable belief that in America, the law protected everyone equally. He believed that with his whole heart until the day he died. He believed it because he had to, because men who come here with nothing need to believe the system won't crush them simply because they have no money, no connections, no name anyone recognizes. I have spent 40 years on this bench trying to be worthy of that belief. That Tuesday morning in February, a man with a federal badge and a loaded weapon was about to test whether I still was. I finished my coffee, straightened my robe, and walked to my bench. Court was in session. Before I tell you what happened when Holt walked through that door, you need to understand what brought him to my courtroom in the first place. Because none of it started with Raymond Holt. It started 6 weeks earlier with a woman named Dolores Mancini and a parking ticket that wasn't really about parking at all. Dolores was 61 years old, retired school teacher, 32 years in the Providence public school system teaching 4th grade. The kind of woman who still sends handwritten thank you notes, who knows every neighbor on her street by name, who brings food to funerals without being asked. She'd come before my court on a single parking violation. $40. Expired meter outside the pharmacy on Elmwood Avenue. Nothing unusual there. I see 40 cases like it every week. But when Dolores stood at my bench that January morning, her hands weren't shaking from nerves the way most people's do. They were shaking because she hadn't slept in 3 weeks. I noticed. After 40 years, you notice. "Mrs. Mancini," I said, setting down the ticket, "are you all right?" She looked at me for a moment like she was deciding something. Then she said very quietly, "Your Honor, I need to tell you something, but I'm afraid." In my courtroom, when someone says they're afraid, I listen. I asked her to speak freely. What she told me over the next 4 minutes changed everything. Dolores Mancini lived on Crescent Street in the Silver Lake neighborhood. Modest house, small yard, same address for 27 years. 3 months earlier, her neighbor, a young man named Marcus Webb, 26 years old, worked 2 jobs, no criminal record, had been arrested by federal agents on drug distribution charges. According to the arrest report, agents had conducted a lawful search of Marcus's vehicle and discovered a substantial quantity of narcotics. Marcus had been taken into federal custody, denied bail, and was awaiting trial. His mother, Gloria Webb, had spent everything she had on a defense attorney. Dolores Mancini had been outside on her porch the evening of Marcus's arrest. She had seen the entire thing, and what she saw did not match the arrest report at all. She watched 2 agents approach Marcus's car before he even exited the vehicle. She watched one of them, a tall man, broad shoulders, dark jacket, open the rear door of Marcus's car himself, reach inside, and place something on the back seat. Then he stepped back, knocked on Marcus's window, and when Marcus rolled it down, the agent pointed to the back seat and called the other officers over. Dolores had gone inside, written down everything she remembered in a spiral notebook, including the time, the license plate numbers of the federal vehicles, and a detailed physical description of the agent who had planted what she believed was evidence. The agent she described matched Raymond Holt exactly. I sat very still while she spoke. Christina had stopped typing. The courtroom, which always has a low background hum of shuffling papers and quiet conversations, had gone completely silent. Everyone in those gallery seats understood they were hearing something serious. Dismissed her parking ticket immediately. Then I picked up my phone and called the Federal Public Defender's office before she had even finished gathering her purse. What followed was 6 weeks of careful, quiet process. Dolores gave a formal statement. The Public Defender's office filed an emergency motion challenging the evidence in Marcus Webb's case. A request went out for Raymond Holt to appear before my court to answer questions about the search and the chain of custody for the evidence recovered from Marcus's vehicle. Standard procedure. Legal, proper, straightforward. Holt refused the first summons. His supervisor at the field office sent a letter explaining that Agent Holt was involved in active federal investigations and his appearance would be inconvenient to those proceedings. I issued a second summons. That one came back with a phone call from someone at the U.S. Attorney's Office, suggesting, in the careful language people use when they want to intimidate without leaving fingerprints, that municipal judges should be careful about inserting themselves into federal matters. I've been on this bench for 40 years. I don't get intimidated by careful language. I issued the contempt citation. Holt was ordered to appear before my court on Tuesday, February 11th, at 9:30 in the morning. And when Christina flagged that file for me that cold gray morning, what she was really telling me was this. The man who had been cornered, who had been formally summoned, who had exhausted every bureaucratic avenue to avoid accountability, that man was now out of options. And a man out of options is the most dangerous kind. Christina refilled my coffee without being asked. I drank it slowly and waited. At 9:28, the courtroom doors opened. Raymond Holt walked into my courtroom, the way men walk when they've decided the room belongs to them. Not hurried, not nervous, not the way most defendants move when they approach my bench. That particular combination of resignation and anxiety that comes from understanding you are about to face consequences. No, Holt moved slowly, deliberately, like a man arriving at a meeting he had already decided the outcome of. 6 feet tall, broad through the shoulders, dark suit pressed sharp, federal badge clipped to his belt where everyone could see it. He wasn't in uniform exactly, but he was wearing that badge like a uniform, like armor, like a message. Behind him came 2 men I didn't recognize, not lawyers. Lawyers carry briefcases and wear the slightly harassed expression of people who are always running 10 minutes behind. These 2 moved differently, hands loose at their sides, eyes scanning the room in that particular methodical way that law enforcement people develop after years of training. They sat down in the second row without being invited and without asking permission, which told me everything I needed to know about how this morning had been planned. The gallery was more full than usual for a Tuesday contempt hearing. Word travels in courthouses. Christina had mentioned the previous afternoon that several people had called asking about the docket. Lawyers who practiced regularly in my court were present, who had no cases before me that morning. A reporter from the Providence Journal sat in the back row with a notepad. And in the far left corner, very still, very watchful, sat a woman I would later learn was the supervising federal public defender handling Marcus Webb's case. She had driven 3 hours from Boston at 5 in the morning to be in this room. They all understood that something was going to happen today. They just didn't know what shape it would take. Agent Holt, Christina called from her desk, her voice professionally steady in the way it always is regardless of what she's feeling. You are before this court on a citation of contempt for failure to appear in response to 2 lawful summonses issued by this court on January 14th and January 28th. How do you respond? Holt didn't look at Christina. He looked directly at me, and he smiled. Not the nervous smile of someone trying to make a good impression, the slow, deliberate smile of someone communicating a specific message. The message was, I am not afraid of you. Judge Caprio, he said. His voice was calm, almost conversational, the kind of voice that has given a lot of orders and received very few. I want to be respectful of your court and your time, so I'm going to be direct with you. This contempt citation needs to be withdrawn this morning. The matters you're attempting to examine fall under active federal jurisdiction and are protected by protocols that supersede municipal court authority. I'm not here to answer questions about any ongoing federal investigation. I'm here as a courtesy, to explain that directly so there's no confusion going forward. I let the silence sit for a moment after he finished. 40 years on this bench has taught me that silence is one of the most powerful tools available to a judge. People who are confident in their position can sit inside silence comfortably. People who are afraid of consequences feel compelled to fill it. Holt held my gaze and said nothing further, which told me he was either genuinely confident or had prepared himself very carefully to appear that way. Either possibility concerned me. Agent Holt, I said, keeping my voice level, you were summoned to this court to answer questions relevant to a proceeding before me involving a Providence resident whose liberty is currently at stake. The nature of your professional responsibilities does not exempt you from a lawful court summons. I issued 2. You ignored both. That is contempt. It is not a matter of federal jurisdiction versus municipal authority. It is a matter of the law applying to everyone equally, badge or no badge. Something shifted in his expression. Barely visible, a tightening around the jaw, a slight hardening of the eyes. The smile didn't disappear exactly, it just became something else, something colder. "Judge," he said, and his voice had changed too, dropped half a register, the conversational ease replaced by something more deliberate. "I've been very patient this morning. I'm asking you, professionally, to reconsider the direction you're taking this. There are people involved in the matters you're poking at who are considerably more dangerous than a parking ticket witness. You're a municipal judge in Providence, Rhode Island. You don't have the full picture here. And people who don't have the full picture sometimes make decisions that put themselves and others in unnecessary danger." The courtroom was absolutely silent. Every person in those gallery seats understood what they had just heard. That was not a legal argument. That was not a procedural objection. That was a threat, delivered quietly, professionally, with plausible deniability wrapped around it like expensive paper around a brick. I took off my glasses, set them down on the bench in front of me, looked at Raymond Holt for a long moment. "Agent Holt," I said quietly, "are you threatening this court?" He reached inside his jacket, and that is when everything in that room changed forever. Time does something strange in moments of genuine danger. It doesn't slow down the way people describe in movies. It doesn't speed up either. It becomes extraordinarily precise. Every detail sharpens. Every sound separates itself from every other sound. I heard the rustle of Holt's jacket as his hand moved inside it. I heard Christina's sharp intake of breath from her desk to my left. I heard the creak of the gallery bench as one of the two men in the second row shifted his weight forward. I heard my own heartbeat, steady and deliberate the way my father's footsteps were steady and deliberate on the construction site, one foot in front of the other, no matter what the ground looked like ahead. Holt's hand came out of his jacket holding a folded document. He placed it on the edge of my bench with the flat, unhurried motion of a man who had rehearsed this moment. "Federal injunction," he said, "filed this morning at 6 a.m. in Federal District Court. It temporarily restrains this court from compelling testimony or producing discovery related to any active Bureau investigation. You'll find Judge Patterson's signature on page 3. He stepped back, straightened his jacket, and the cold smile returned. "I believe that resolves the matter, Your Honor." I looked at the document without touching it for a moment. Then I picked it up, read it carefully. Every paragraph, every subordinate clause, every carefully constructed sentence designed to sound absolute and final and beyond question. The two men in the second row were watching me the way people watch a door they expect to open. The reporter in the back had stopped writing and was simply staring. Christina had not moved. Here is what I knew in that moment. The injunction was real. Judge Patterson's signature was real. The federal authority cited within it was real. And none of that changed a single thing about what was sitting in my courtroom that morning, which was a man who had watched another man plant evidence on an innocent person and had said nothing, done nothing, and then spent 6 weeks using every institutional tool available to him to make sure no one ever asked him about it under oath. I set the document down. "Agent Holt," I said, "I've read this injunction. I'll have my clerk file it appropriately, and I will consult with the appropriate authorities about its scope and application. That is the proper process, and I will follow it." I paused. "However, this injunction addresses the question of compelling your testimony regarding an active federal investigation. It does not address the contempt citation itself, which was issued for your failure to appear in response to a lawful summons. Those are two separate legal matters. The injunction resolves one of them. It does not resolve the other." For the first time that morning, something genuine moved across Holt's face. Not fear exactly, something closer to surprise. The surprise of a man who had prepared for every response except the one he received. "Judge," he said, and the professional patience in his voice had developed a visible crack. I came here this morning in good faith with a federal court order. I'd strongly suggest, Agent Holt. My voice was quiet. After 40 years, I have learned that a quiet voice in a silent room carries further than a raised one. You came here this morning because I compelled you to come. You brought two colleagues whose names do not appear on any filing before this court and who have not identified themselves or their purpose. You delivered a document that you or someone working on your behalf prepared before dawn this morning in what appears to be a significant and coordinated effort to prevent this court from exercising its lawful function. That is not good faith. That is obstruction, dressed in a suit and carrying a badge. The courtroom was so still I could hear the February wind against the windows. Holt stared at me. The smile was entirely gone now. In its place was something I recognized from 40 years of watching people stand at my bench and realize that the outcome they planned for is not the outcome they are going to receive. It is a particular kind of recalibration. You can see it move through a person's body, from their eyes down through their jaw and into their shoulders. The two men in the second row had both leaned forward now. One of them had his hand resting on his knee in a way that was not casual. I'm going to ask you to surrender your weapon to the court officer for the duration of these proceedings, I said, looking directly at Holt. Standard procedure for any armed individual appearing before this bench. I'm a federal agent, Holt said. His voice had gone flat and hard. I don't surrender my weapon to a municipal court officer. Officer Reyes, I said, without breaking eye contact with Holt. Officer Daniel Reyes, my court officer. 15 years on the job, one of the steadiest men I have ever worked with, stepped forward from his position near the side wall. That is when Raymond Holt reached inside his jacket a second time. And this time, what came out was not a document. The gun was out for perhaps 4 seconds before Holt seemed to register what he had done, what the room had witnessed, what every person in those gallery seats had just watched a federal agent do inside a courtroom in broad daylight, with a reporter sitting in the back row. 4 seconds. Long enough for Christina to push back from her desk. Long enough for 3 people in the gallery to stand. Long enough for Officer Reyes to place himself between the weapon and my bench with a composure that I will respect for the rest of my life. Long enough for everything to change. Holt lowered the weapon. His face had gone the color of old concrete. Whatever plan he had walked in with that morning, the injunction, the colleagues, the careful professional pressure, it had just collapsed entirely under the weight of what his own hand had done. He looked at the gun like he was seeing it from outside himself. Like some other version of Raymond Holt had made a decision that this version was only now understanding the consequences of. Agent Holt, I said. My voice was steady. I want you to understand that my voice was completely steady. Not because I wasn't shaken. I was shaken to my core. But my father worked a construction site for 30 years with a back that caused him daily pain, and he never once let it change the quality of his work. Steadiness is not the absence of difficulty. It is the decision to continue despite it. Put the weapon on the bench in front of you. Do it now. He put it down. Officer Reyes secured it in 4 seconds flat. The 2 men in the second row had risen to their feet, but neither had moved further. They were looking at each other with the expression of people rapidly calculating how far this situation had traveled beyond their original instructions. I picked up my phone and called the state police. The state police arrived in 11 minutes. I know because I watched the clock on the courtroom wall the entire time. The same clock that has hung in that room for longer than I have been its judge. Its black hands moving with the same indifference to human drama they have always shown. 11 minutes. In that time, nobody in the courtroom moved. Nobody spoke above a whisper. Raymond Holt stood at the defendant's table with his hands flat on the surface in front of him, staring at a fixed point on the floor. The 2 men from the second row had identified themselves finally. Both bureau agents, both there on Holt's request, neither of them apparently aware that their colleague had intended to draw a weapon inside a courtroom. You could see that on their faces. The sick, hollow expression of people processing that someone they trusted had just destroyed everything. Officer Reyes stood between Holt and my bench the entire 11 minutes. Never moved, never wavered. I have already written a formal commendation for his file. When the state troopers arrived and took Holt into custody, he didn't resist, didn't threaten, didn't reach for the professional composure he'd walked in wearing that morning. He just looked smaller. The badge on his belt, the decorated career, the 17 years of commendations, none of it was visible anymore. What was visible was a man who had made a catastrophic decision and was only now, in the most complete and irreversible way, understanding its weight. Marcus Webb was released from federal custody 19 days later. The evidence against him was formally dismissed after an internal bureau investigation confirmed what Dolores Mancini had watched from her porch on Crescent Street 3 months earlier. The agent who planted that evidence was not Raymond Holt. Holt had been the supervisor on scene, the man who had allowed it to happen, who had filed the report that buried it, who had spent 6 weeks trying to keep a municipal judge from pulling that thread. He was charged with obstruction of justice, evidence tampering, and conduct unbecoming a federal officer. He pleaded guilty 14 months later and was sentenced to 4 years in federal prison. He lost his badge the same day. Dolores Mancini sent me a letter when Marcus came home, written in that careful, unhurried handwriting of a woman who spent 32 years teaching children that words matter and therefore chose hers with great care. She wrote, "Dear Judge Caprio, Marcus came home on a Thursday. His mother Gloria made red beans and rice, his favorite, and the whole street came out. I watched from my porch, the same porch where I watched them take him away, and I thought about how close it came to going differently. Thank you for not being afraid. Thank you for not backing down. Some people spend their whole lives waiting for the system to work the way it's supposed to. You reminded us it still can." I folded that letter and put it in my desk drawer, where I keep the ones that matter most. My father used to say, "Frank, the law is only as strong as the people willing to stand behind it when standing is hard." Raymond Holt walked into my courtroom that February morning, believing that a badge made him untouchable, that institutional pressure could bend a municipal judge into silence, that justice was negotiable if you applied enough force in the right places. He was wrong. In 40 years on this bench, I have learned one thing above everything else. Justice doesn't care how powerful you are. It doesn't care about your badge, your injunction, your colleagues in the second row, or the weapon inside your jacket. Justice only cares about one thing: whether someone in the room is still willing to stand up for it. That morning in that cold Providence courtroom, I was. I'm Frank Caprio. Remember, the law is not a suggestion. It is the floor beneath all of us, and it holds because people choose to hold it. Thanks for listening, and God bless.